Good morning, ladies and gentlemen. Might I invite all of you to kindly rise from your seats in welcoming our chief guest and guests of honor for this ceremonial opening session of the National Law Conference 2020, a hybrid conference, both physical and virtual. In beginning this morning's August proceedings, it is my pleasure to invite our distinguished invitees, the following whose names I shall announce, to kindly oblige in the traditional lighting of the oil lamp. My invitation goes out to our chief guest and the Chief Justice of the Democratic Socialist Republic of Sri Lanka, His Lordship President's Counsel Jayantha Jayasuriya, to kindly oblige. And might I also invite the Minister of Justice of the Democratic Socialist Republic of Sri Lanka, being our guest of honor, President's Counsel Honorable M.U.M. Ali Sabri, our guest of honor, the Honorable the Attorney General of the Democratic Socialist Republic of Sri Lanka, President's Counsel Dapula Dilivera, the President of the Court of Appeal and our guest of honor, His Lordship Justice Arjuna Obesekara, our guest of honor and Chairman of the Law Commission of Sri Lanka, President's Counsel Romesh De Silva, President of the Bar Association of Sri Lanka, President's Counsel Kalinga Indathissa, the Chairman of the National Law Conference 2021, Attorney at Law, Mr. Hirandi Alvis, the Secretary of the Bar Association of Sri Lanka, Attorney at Law, Mr. Rajiv Amarasuriya, and the Treasurer of the Bar Association of Sri Lanka, Attorney at Law, Mr. Nalin De Silva. Kindly oblige. Thank you, sir. Invite the Acting Solicitor General of the Democratic Socialist Republic of Sri Lanka, President's Counsel Sanjay Rajaratnam, to kindly oblige in the traditional lighting of the oil lamp. Thank you, gentlemen. If you will kindly remain standing for the national anthem.
Sri Lanka Mata, Appa Sri Lanka, Namo, 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 Namo Mata. Sundara Sri Parini, Surani Ati Sopamana Lanka. Danya Dhanaya Nikaman Palaturu Piri Jaya Bhumiya Ranya. Appa Hatta Sabba Siri Santa Sadhana, Jivana Ye Mata. Dili Danu Mena Appa Bhakti Puja, Namo Namo Mata. Appa Sri Lanka, Namo Namo, Namo Namo Mata. Obave Appa Vidya, Obamaya Appa Satya, Obave Appa Shanti,
Thank you, ladies and gentlemen. May I now invite our guests at the head table to kindly take their seats. My invitation goes out to our chief guest, His Lordship the Chief Justice, our guests of honor, the Honorable Minister of Justice, Honorable the Attorney General, the Honorable President of the Court of Appeal, the Chairman of the National Law Commission, President's Counsel, Mr. Romesh De Silva, the President of the Bar Association of Sri Lanka, Mr. Kaling Indathissa, President's Counsel, the Chairman of the National Law Conference, Attorney at Law, Mr. Hirandi Alvis, the Secretary of the Bar Association of Sri Lanka, Attorney at Law, Mr. Rajiv Amarasuriya, and the Treasurer of the Bar Association of Sri Lanka, Mr. Nalin De Silva, to kindly take their seats at the head table. Thank you. Might I also invite the Acting Solicitor General of the Democratic Socialist Republic of Sri Lanka, President's Counsel, Mr. Sanjay Rajaratnam, to kindly take a seat at the head table. Thank you. Ladies and gentlemen, it is slightly strange that this is not a traditional national law conference that we are most used to. This is, like most cars were a few years ago, hybrid. And by that, we mean that it is both physical and also virtual. Whilst you good ladies and gentlemen are physically present here with us today, numbering close to 75, we have close to 200 participants joining us virtually online. It is now my pleasure to therefore invite the Chairman of the National Law Conference 2021, Attorney at Law, Mr. Hirandi Alvis, to deliver the welcome address.
Lordship the Chief Justice, Honorable Minister of Justice, Honorable the Attorney General, Your Lordships, Chairman of the Law Commission, President of the Bar Association, Secretary of the Bar Association, distinguished invitees, ladies and gentlemen, welcome to the National Law Conference of the Bar Association Sri Lanka in its hybrid form. The preeminent academic conference of the Bar Association is important for legal practitioners, professionals, and all allied to the legal field, whereby discussions and deliberations can be made on the law and the future manifestation of the law in its practical realities and implementation. Accordingly, the theme of the conference is futurism, and it is timely. It is an attempt, accordingly, to envisage a future from the present new normal to a new dynamic. The concept of futurism was developed by Italian art students in the 1920s. Coincidentally, it arose after the horrors of the First World War and the Spanish flu epidemic, which caused immense destruction worldwide. Accordingly, it is apt now that we, after periods of unrest and an unforeseen health crisis in this country, and the resulting disruption in economic activity, have focused now to look at things afresh and to fashion a new future. That is futurism. I do not subscribe to the term new normal. It means continuation of chaos. Therefore, the legal profession, may I humbly state, should look at fashioning a new dynamic and accordingly, futurism. Upon the appointment by the Bar Association of Sri Lanka and the EXCO as chairman of this conference, me and my committees and the conveners were faced with an unprecedented challenge of converting a normal two-day residential conference to a hybrid virtual conference due to this situation. Whilst we celebrate our proud legal heritage, we must all work towards fashioning a positive future. To paraphrase Justice Oliver Wendell Holmes, however, the law must reflect the felt realities of the times. The conference logo reflects Lady Justice and the rule of law protecting Sri Lanka, its landmass, maritime zones, in economic relations, international relations. Accordingly, the Bar Association, in my view, should be the premier professional body in Sri Lanka and be in the forefront of legal changes. It is in this light that the committee took up this challenge in limited time and space and worked tirelessly to enable this vision into reality. It was decided to have this conference prior to the conclusion of the tenure of the present president of the Bar Association, and we also acknowledge the dynamism of the younger secretary of the Bar Association, Mr. Rajiv Amrasurya, the management committee, EXCO, and the staff. Coming to the conference, we decided to focus on some areas out of the box, which we perceive to be challenges at present and possibilities for the future. The broad areas and topics have been drafted in that spirit. Since there have been concerns raised as to the ease of business rankings, we planned a session on effective enforcement of business contracts. In my opinion, there is nothing called laws delays. It is a misnomer. There cannot be a meaning to that term. Based on our wide and varied experience of all the professionals in the bar, we can state that what is primarily needed is effective enforcement of the existing laws. We are enriched by various streams of law. The infrastructure for the enforcement of that law is needed to be modernized, and one such methodology is the digitalization and simultaneous translation processes, etc. It is also planned to focus on new shareholder possibilities, such as real estate investment trust, the new SEC Act, issues arising out of increased digital banking, issues caused to non-banking financial institutes and the customers. It was also planned to focus strongly with local and foreign expertise on electronic transmission of records and the international cross-border data flows. The importance of exploiting our natural maritime resources, exclusive economic zone, which is 3 times our landmass and a great resource for the country, is also to be looked upon. With new developments, the challenges in new fields of criminal law have not been forgotten. Therefore, we will look at cyber crimes, anti-money laundering, etc. Then the relatively hushed up topic causing immense damage to children and parents, such as child abuse and mental abuse and harassment, is to be focused on with earnest. The untrammeled and often helpless situation of defamation in digital space and whether the law should be helpless and how to grapple with same within the existing legal principles are to be looked at. With new vistas and possibilities opened up with the growth of sports as an entertainment and professional industry, we are focusing on importance of contracts, TV rights, sponsorship, and doping issues. With the progress and importance of protecting, with this progress, the importance of protecting and nurturing fundamental freedoms of the people, including religious and language rights, are also to be debated. As we embark on the future, the importance of fashioning the profession to meet the future with recourse to perceived changes such as limited liability partnerships for professional firms, increase opportunities for our younger men and women of the legal profession would be also brought into focus, together with the importance of maintaining ethics in the profession and maintaining professionalism. Accordingly, it is in keeping with our overall theme that such new paradigms and areas were focused with inputs from various perspectives, including other professionals who will be joining our discussions. Whilst expressing my regret at not being able to thank individually all who helped enormously to effect this change, briefly I thank the Bar Association, the Management Committee for the confidence reposed to organize this conference. I also thank the distinguished guests, our distinguished panelists, all participants, our partners and sponsors, many seniors and juniors from my chambers for their invaluable support. Accordingly, I trust that this conference and its deliberations and participation would help to fashion and guide new developments in the law and to make it a reality in its practical application. We envisage diverse viewpoints to generate a healthy discourse and to be able to fashion the future and to guide the law accordingly. Thank you very much.
Thank you, Mr. Chairman. It is now my pleasure to invite the President of the Bar Association of Sri Lanka, President's Council Kalingi Indatissa, to address this conference.
My Lord the Chief Justice, Honorable Minister of Justice, Honorable the Attorney General, the President of the Court of Appeal, Honorable Justice Obesekara, Mr. Ramesh Silva, former President of the Bar Association and Chairman of the Law Commission, Honorable the Solicitor General, Chairman of the National Law Conference, ladies and gentlemen. During 2020, we went through unprecedented times, and it appears that that experience is to continue in the recent future. In this context, I'm extremely happy as the President of the Bar Association for putting up this event, which is normally one of the most important events in the calendar of the BSL. The National Law Conference gives us an opportunity to periodically and meet and discuss laws for the future, laws which have been debated, and necessary law reforms. In the context of the COVID-19, it is indeed remarkable that the committee headed by Mr. Hiran Dialvis has put a lot of effort to make this event a reality. I know the tough times that you have gone through. I know how much of effort that the committee has put in, and I'm ever so grateful to the committee, the chairman and the members of the committee for putting this event together for the benefit of the membership. If you go through the agenda, which has been planned for today and tomorrow, ladies and gentlemen, there are several important topics that we intend to discuss through the respected resource persons. And there are several topics which would be indeed necessary for consideration, all those consideration of the lawmakers and the honorable judges of the apex courts of this country, considering the times that we are going through. Very recently, e-filing was introduced in the superior courts. There are so many challenges that the bar, the bench, and even the legislature would have to face. There are certain areas of the law where the law needs reform. In that context, I'm extremely happy our Minister of Justice has taken a lot of steps with the assistance of the Bar Association to identify the necessary law reforms which are immediately required to upgrade the laws in this country. I'm also glad that there is a considerable amount of participants who, despite the situation that we are going through, have consented to be participants and agreed to be participants on this, at this event. Ladies and gentlemen, as I said before, whatever the outcome that would be considered at the end of the conference, most of these areas would have to be condensed and submitted wherever law reform appears to be necessary. That's a function that the BSL would do and submit it to the relevant authorities for their consideration. Without taking much time, I once again thank the Management Committee, the Efficient Secretary, Mr. Rajiv Amarasuriya, all of you who are gracing the head table, gracing as guests on this occasion, and all the participants, the sponsors, and the members of the organizing committee for putting up this event together. And I hope that the physical participants and the virtual participants would gain the maximum advantage of the topics that would be discussed in the next 1.5 days. Thank you very much.
Thank you, Mr. President of the Bar Association of Sri Lanka. Ladies and gentlemen, it is my privilege to now read to you the message of His Excellency, the President of the Democratic Socialist Republic of Sri Lanka, sent for the inauguration of the National Law Conference 2021. It is indeed heartening to note that this year's National Law Conference of the Bar Association of Sri Lanka has as its theme futurism, and that discussions and deliberations will be focused on the future developments of the law. I am indeed pleased, therefore, to issue this message at the inauguration of the conference, not only to wish the conference all success, but also add a few thoughts with a view to enrich the discussions aimed at fruitful outcomes. Every government has had to think strategically after the unforeseen health debacle derailed all plans for development. As Sri Lanka too is embarking on newly thought out initiatives, the conference, I am certain, could focus its attention without deviating from its theme, how the law could facilitate the country's march forward in the new normal. Sri Lanka is a democratic nation. Every citizen who lives in this country has equal rights. Our government is committed to protect the fundamental rights and human rights of all our citizens and firmly stands for the principle of one nation, one law. Even with unanticipated disruptions to people's way of life, our government is committed to ensure peace, stability, and prosperity for every citizen of our country. The rule of law and how the law could facilitate efficient conduct of governance should also attract attention of those who will guide the discussions at the National Law Conference. Gama Samaga Pilisandarak is a program in which I visit a very remote village every week and has enlightened me on how poor rural citizens suffer due to their ignorance of the law governing their day-to-day life, and as a result of what extent they are entrenched in never-ending misery. Legal luminaries must examine how these poor villagers could be saved from these legal proceedings, perhaps by simplifying the law and educating the citizenry on compliance. I have appointed a commission on the simplification of existing laws and regulations in the interest of the people to change certain outdated laws and regulations that affect the general public as well as the domestic and foreign companies in carrying out their business. It is my wish that the National Law Conference of the Bar Association of Sri Lanka takes a holistic view of our laws and regulations and make recommendations to the government with a view to help citizens carry out their day-to-day activities with ease and also contribute towards the development of the country. I wish the conference all success. Signed on this 11th day of February 2021, Gotabaya Rajapaksa, President. Ladies and gentlemen, it is now my privilege and also my pleasure to invite the Chairman of the Law Commission of Sri Lanka, President's Council, Mr. Romesh De Silva, to deliver the keynote address.
Your Lordship, the Chief Justice, Honorable Attorney General, Honorable Minister of Justice, Honorable the President of the Court of Appeal, distinguished members of the head table, learned President's Council, ladies and gentlemen. Futurism is defined in the Oxford Dictionary as a movement in art, literature, music, etc., with violent departure from traditional norms so as to express movement and growth. Emphasis, violent departure from traditional norms. The term futurism, ironically, has no place in the Oxford Dictionary of Law. In fact, even future is not defined in the Oxford Dictionary of Law. It simply shows that law and lawyers rarely think of the future or law in the future and so lags behind. In this context, it is apt that the National Law Conference 2021 has chosen as its theme futurism. Law has to cater to the needs and aspirations of society and has necessarily to mold itself to suit the requirements of society. And as just we heard His Excellency say, particularly the requirements of the less privileged and the poor of our society. In this context, may I quote from Professor Rule, the David Daniels Ellen Distinguished Chair in the Law in Wentworth University, where he says, quote, "Legal futurism is interdisciplinary, drawing from many legal and non-legal disciplines to understand the social, economic, technological, and environmental realities that will necessitate the law to adapt and change, whilst also opening up new legal opportunities. So, to be clear, legal futurism means you understand the society that you want and you have the law to meet the aspirations of that society. In these circumstances, any useful discussion in futurism must necessarily have before it a socio-economic, sociological, political analysis of what society would be in the future. And it is only then that legal futurism can be decided. Law, the future society has to be determined and the law meant to go into that society. However, law has to be ready to face the violent departure from traditional forms if there is to be any meaningful discussion on futurism. More importantly, we the lawyers and the judges have to be ready and willing to violently depart from the traditional forms to face an evolving society which evolves at great pace. To ask a hypothetical question, are judges and lawyers garbed in the attire of centuries gone by, ready to take a violent departure or a departure at all from their spheres of comfort? If not, this seminar will be a waste of time. In this context, it might be important to remember the words of Professor David Funk, written almost 50 years ago, where he said, "Most legal thought is lavish on interpreting records of the past or reinterpreting them for guiding behavior in the present and immediate future." The Hague Institution for Internationalization of Law says, quote, "Legal futurists are not widespread among legal scholars and practitioners. Compared with the extensive body of literature of the history of law, there is limited scholarly work on the long-time future. Some scholars give focus on the future of the law, but through very particular prisms, such as how technology will change. Others address the future of only specific legal areas. Sometimes the future of legal traditions is questioned." As he goes on to say, quote, "On the whole, a limited time horizon of lawyers tends towards use of the most recently adopted law or court decision. They tend to look back and argue whether that particular law or decision will or will not work, instead of systematically studying the future and future uncertainties. The lawyer's way of dealing with uncertainties is to act through unadopted and contemporary norms, decisions, and institutions." This is what we are trained to do. Look at the law, look at law reports, try to interpret them and fit them. We do not have the training to look into the future and to see what we need to bring the law to be meaningful to the society of the future. Therefore, in my view, a paradigm shift is essential. In thinking is essential. It is necessary for lawyers and judges to come out of their comfort zone and think of the future with courage. Courage is necessary and needed to cruise through uncharted waters. And I want to remind ourselves that we must not delude ourselves by thinking of what the future is. For instance, quite often this example is given. A seller in China buys from a buyer in New York, contract signed in Italy, goods to be delivered in Sri Lanka, consideration to be paid in England. What's the law? That's not future. That's past, way past. So in this seminar, I want to remind all of us that we must not delude ourselves in thinking that that is the future when that is not. Therefore, the future can be divided into short term, medium term, and long term. Short term perhaps will be 1 year, which is February 2022. Medium term will probably be February 2024 and long term February 2026. It is good to remind ourselves that in the early stages of our independence, we had 10-year and 5-year plans, which we unfortunately do not have today. It may be opportune for the legal fraternity to develop at least a 5-year plan. Then you find out what you want, what society will be in 5 years, what you want the law to be in 5 years, and what you should do today to have that reality in 5 years. To be of any use, it must also give and come up with practical solutions. So rather than talk of historic topics at this seminar, I urge you to spend some time to be practical. As Professor Rule said, quote, legal futurism is both theoretical and practical, discussing what the law may look like in the future, as well as how lawyers would participate in such a future. To be practical then at this conference, I would like to focus mainly on the short term. However, before doing that, I want to place for the consideration of this seminar a matter that would require a long-term solution. As you are aware, we are now at the advent, or perhaps past the advent of artificial intelligence. Research, pleadings, and submissions may now be done by artificial intelligence. Are you then eliminating lawyers, and certainly junior lawyers, a gruesome future? Professor Valentine Karslick at the University of Massachusetts has created artificial intelligence machine that now writes political speeches. These speeches in Congress by both Republicans and Democrats deal with a wide spectrum. There are speeches developed to be delivered in the United Nations, which deals with topics ranging from nuclear disarmament to climate change and immigration. In these circumstances, researchers and speech writers have tended to be redundant. Will the same apply to lawyers when artificial intelligence creates pleadings? Since the Honorable the Minister of Justice is leaving, I had intended to say this at the beginning, at the end, but I want to take this opportunity to expressly, sincerely, and publicly applaud the Honorable the Minister of Justice for all the good he is doing, for his innovative thinking, and we are very grateful to him. I'm sure there will be some mistakes on the way, but thank you very much, sir. So as I was saying, with artificial intelligence, researchers and speechwriters have also tended to be redundant. Will the same apply to lawyers when artificial intelligence creates pleadings, evidence in chief, written submissions, and all authorities? Even today, the availability of references by the click of a button has made several lawyers who functioned as research officers, several juniors, redundant. Judgments can possibly be written by artificial intelligence and may even be better than some of the judgments we see today. So the bar must face this challenge and come out with a solution if they wish to prevent lawyers becoming redundant. As I said before, to be practical, I wish to focus specifically on the short term, because in my view, something practical could possibly be done. In this context, I want to focus on the following: the backlog of work. The chairman has said there is no laws delays, so I don't want to use that term. 2, laws that deal with the internet, and 3, ethical conduct of lawyers and digitalization. On the laws delays, I wish to focus purely on the Supreme Court, but the laws delays across the board, but just to be practical, I attempted to get statistics of cases pending in the Supreme Court and the approximate number of cases filed per month in the Supreme Court from the registrar of the Supreme Court. The registrar, unfortunately, was singularly unhelpful in that he demanded from me a written request asking me to explain the capacity in which I am asking for this information and why I require this information. That I refused to do. Therefore, I had to turn to other sources to get this information, and I readily got it. Unfortunately, the researchers to which I turned had information only to the end of 2019. Now, at the end of 2018, there were 4,331 cases pending in the Supreme Court. In 2019, there was 1,873 new cases filed. And in 2019, the cases concluded was 1,437. So there were about 300 more cases filed and concluded, and therefore the backlog was added to, and you had 4,767. Now, if you continue this trend, the backlog will keep increasing. To be realistic then, let us take for example that the Supreme Court wishes to clear 1,000 cases from the backlog. There are approximately 1,900 cases filed per year. That includes leave to appeal, special leave, fundamental rights, and so on. So that would mean that the Supreme Court will have to hear 3,000 cases approximately if they wish to reduce the backlog by 1,000. This means that the Supreme Court would have to hear 300 cases per month. 2 months of the year, generally vacation. 3,000 divided by 10 would be 300 cases per month. This would be approximately 15 cases per day for approximately 20 working days. Since we now have 3 benches sitting, this will be approximately 5 cases to be concluded per bench per day. Now, that theoretically does not seem much, but practically will it happen? So this is the matter I want to leave with you. You talk of futurism. This is the goal we must set ourselves in 2022, so that by February 2022, if we can reduce the backlog by 1,000 by cooperating with the bench. We as lawyers have to cooperate with the bench into ensuring that 5 cases per day will be finished by each bench. If that is so, you get the backlog down by 1,000 cases. So if this seminar is to be meaningful, these are the future steps, the steps you must take today to ensure a good future in February 2022. Then, 2, the laws that deal with internet. Today, increasingly, citizens of this country are using social media, and correctly so. Thus, there's an urgent basis for laws that control the proper use of social media and control abuse. From the Law Commission, we have proposed laws that criminalize invasion of privacy. For instance, uploading photographs of sexual explicitity without the written consent of the person, taking photographs in private functions and uploading it in the media. For instance, we all behave at private functions in some particular way. There's nothing wrong, but that's not a thing that we would like uploaded. So we have brought in some laws, but these are matters that your seminar also can discuss, to see what sort of laws there must be to control the invasion of privacy in the social media. The other is the ethical conduct of lawyers. The standard of professional ethics to be adhered to by lawyers are described by the Supreme Court Conduct and Ethics for Attorneys at Law. For example, the Supreme Court rules prohibits touting, and this is said to include advertising in any manner for the purpose of unfairly attracting clientele for himself. Now, how does that reflect in the social media? Is maintaining a link in profile be considered to be unfair advertising? Can sharing photographs on Instagrams, Facebooks, or Twitter of a lawyer with high-profile clients be considered unfair advertising? Is advertising legal services through paid advertisements on Facebook or paying Facebook to promote one's page unfair advertising? The Supreme Court rules also prescribe that a lawyer can display their professional nameplate office under strict guidelines. Among other things, it prohibits having illuminated nameplates or boards showing directions to the office of an attorney at law. How should this be interpreted and implemented in the context of social media? Rules 60 and 61 prohibit lawyers from conducting themselves in any manner which would reasonably be regarded as disgraceful or dishonorable by lawyers of good repute and incompetency. How should this be interpreted in the case of social media? In this context, how does the law deal with lawyers who upload the cases they appear in on social media, discuss the cases, and discuss their victories? How does the law deal with lawyers who post photographs of themselves together with clients and judges on social media? So these are all practical things that should be done if you want to achieve something in February 2022. Then the role of lawyer. Now the role of instructing attorneys and counsel seem to have disappeared. So it is necessary for the bar to focus on what the role of a lawyer is and what is expected. The digital hearings. The Supreme Court, and credit given to His Lordship the Chief Justice, has passed rules called the Supreme Court Electronic Filing and Urgent Digital Virtual Hearing Special Provisions Rules. Now, this is laudable, but several matters arise. For shortage of time, I don't want to elaborate, but the law has to keep in touch and keep abreast of how to deal with these digital virtual hearings. And lastly, we are having somewhat disturbing things in which there are attempts to take certain parts of this country out of our jurisdiction, like the port city, allied projects, maybe terminals. So the bar has to be vigilant and divide those subjects. Now, what I have set out are some of the problems, and if this conference is to be realistic, it has to examine those problems to see then what we will have in February 2022. There is, in my view, hardly any necessity to discuss various laws if we don't have a goal, either February 2022, 5-year plan, 10-year plan, somewhere, and have those laws in order to meet the society. So the first is to have a study, sociological, political, economic study of society, and do something. That is why I focused on the short term, so that in 2022 February, if we want to have 1,000 cases out, this is what we should do. And since the President of the Court of Appeal is here, I think there's several meaningful steps taken, and we are very confident that by February 2022, the backlog of the Court of Appeal will be drastically reduced. So, in these circumstances, a seminar of this nature can play a big part in formulating legal thinking, at least in the short term. That is from February 2021 to February 2022. If this seminar achieves that in some way, it will be a success. So therefore, we have to be practical when dealing with the future. Before concluding, may I congratulate Mr. Hirandi Alvis and his team for organizing this seminar, and thank Mr. Kalinga Indatissa and Mr. Rajiv Amrasule. Mr. Rajiv will be here, but Kalinga Indatissa for the last 2 years of his stewardship. In conclusion, I wish the seminar all success. Thank you very much.
Thank you, sir, for a very informative and inspiring presentation, and also for the challenge posed to us to change, to evolve the ethos, not only of this conference, but also of the legal fraternity. Thank you. And now, ladies and gentlemen, to conclude this inauguration, I have the pleasure of inviting the Secretary of the Bar Association of Sri Lanka, Attorney at Law Rajiv Amarasuriya, to present his concluding remarks.
My Lord, the Chief Justice, Attorney General, Honorable Dapula Delivera, President's Council, His Lordship, the President of the Court of Appeal, President of the Bar Association of Sri Lanka, Mr. Karling in the TISA President's Council, the Acting Solicitor General, Mr. Sanjay Rajaratnam, President's Council, our keynote speaker today, Mr. Romesh De Silva, President's Council, Chairman of the National Law Conference 2021, Mr. Irandi Alvis, President's Councils, distinguished invitees, ladies and gentlemen. It is my privilege and honor to make a few concluding remarks at the conclusion of today's inauguration of the National Law Conference 2021. All the speakers before me spoke of the new normal, the challenges posed, and the new way of doing things. We did not attract COVID-19 by choice. President Donald Trump called it the Chinese virus. We still do not know where it actually originated from, but it has affected the entire world without consideration of wealth, power, or status. The world has lost a good year and over 2.3 million lives, and many mistakes have been made, but that is now in the past. And we do not need to be fortune tellers to predict that the world will move on. And 5, 10, 15, and 20 years down the line, there will be case studies on how each country and each institution tackled this pandemic, and also how everyone converted the pandemic into a catalyst for progress and development. This pandemic highlighted that there is a lot lacking in our legal system, which should have been corrected, not now, but decades ago. But yet, we have kept chugging along year by year. But that is also in the past. The pandemic has provided us with a new window of opportunity to leapfrog and catch up on what we have missed out. Digitalization of our administration of justice system has been something discussed for a couple of decades, but the pandemic has created an environment where every stakeholder now appreciates the real benefits of digitalization. The Ministry of Justice, headed by the Honorable Minister, has launched multiple initiatives to fast-track digitalization at all levels. And just last week, the Supreme Court also promulgated a new set of rules to facilitate these developments. Even at the Bar Association, we have been doing our part. We have in the past 10 months converted all our professional development activities to online platforms through which we reach out to the entire membership. And later in the evening, we'll be launching a state-of-the-art brand new website, complete with a payment gateway, e-store, and online services. We have not stopped at that. And now we are at the final stages of opening the BASL's first virtual support center, which will enable members to connect to virtual courts and other virtual hearings when required. We need to take forward these changes with courage and with an open mind. There may be some hurdles and obstacles on the way, but we will together overcome those. It is in these circumstances that the National Law Conference Organizing Committee came up with the very apt theme for this conference, Futurism. And we are thankful and indebted to the chairman, the versatile and amiable Mr. Irandi Alvis, the conveners, Ms. Ushani Demuni, Mr. Rajin Pereira, Ms. Lakshika Ratnayaka, and the other members of the organizing committee for taking the challenge and organizing this conference within a very difficult environment. Before the pandemic, Mr. D'Alvis and I had a conversation on how we could broad-base the participation of this conference. And the pandemic provided that opportunity through virtual participation. And we have today members from across the country, and I also understand that some from overseas as well. I'm sure this will be the first of many conferences which will have virtual participation. There will be a formal vote of thanks at the end of this conference, but I must take this opportunity to thank His Lordship, the Chief Justice, the Honorable Minister of Justice, the Honorable Attorney General, the President of the Court of Appeal, the Honorable Acting Solicitor General, and the other distinguished invitees for participating at today's inauguration. The Bar Association is appreciative of your support that each one of you provides to the BSL on a continuing basis. I must also make special mention of Mr. Romesh De Silva, President's Counsel, for the very insightful keynote address today and for his advice and support given to the BSL on a regular basis. I must also thank the BSL staff who provided their fullest support and assistance to the organizing of this organizing committee and the event managers, in spite of being in the middle of organizing an election. We have 2 whole days of an extremely interesting and professional lineup of sessions. And I will like to conclude by extending my very best wishes to the conference and all the participants for insightful and thought-provoking sessions. Thank you.
Thank you very much to our dynamic Secretary of the Bar Association, Mr. Rajiv Amrasurya. Ladies and gentlemen, before we rise from our seats to end this inauguration, if we can call it a COVID positive, or if we can reordain the phrase COVID positive, which has now become almost a bad word in society, it would be, a COVID positive would be our embracing of futurism. Not because of a progressive choice, but more because of compelling necessity. However, a COVID positive would be the embracing of new technology and futurism, as is themed at this conference. Before we conclude the inauguration, I have the pleasure of inviting the conference chairman, Mr. Hiran D'Alvis, to present tokens of appreciation to the distinguished members of the head table, beginning with our chief guest, His Lordship, the Chief Justice. Whilst we thank him for attending, we hope he takes back pleasant memories from this hybrid conference. A token of appreciation to our guest of honor, the Honorable the Attorney General, President's Counsel, Dapula de Oliveira. A token of appreciation to the Honorable President of the Court of Appeal, His Lordship Justice Arjuna Ubesekara. A token of appreciation to the Acting Solicitor General, President's Counsel Sanjay Rajaratnam. A token of appreciation to our guest of honor, Chairman of the Law Commission and our keynote speaker this morning, President's Counsel, Mr. Romesh De Silva. A token of appreciation to our Secretary of the Bar Association, Attorney at Law, Mr. Rajiv Amrasurya. And on behalf of the Executive Committee of the Bar Association of Sri Lanka, might I invite our Secretary, Mr. Rajiv Amarasuriya, to kindly oblige in presenting tokens of appreciation to the conference chairman and the conveners of the National Law Conference Committee. Might I invite Mr. Amarasuriya to present a token of appreciation to the chairman of the National Law Conference Organizing Committee, Attorney at Law, Mr. Kirandi Alvis. A token of appreciation to the co-convener of the organizing committee, Ms. Yoshani Demuni. A token of appreciation to the co-convener, Mr. Rajendra Pereira. A token of appreciation to co-convener, Ms. Lakshika Ratnayaka. Thank you very much. Thank you very much, Mr. Amarasuriya, for so kindly obliging. Ladies and gentlemen, I thank you very much for your participation. I thank the head table, and I wish you all inspiring deliberations at the conference. Thank you.